Do I have to go to court to contest a trust? Yes. To contest any aspect of a trust, most likely you're going to need to file suit in probate court. That does not necessarily mean that you can't settle the case before or after you file your case. However, to formally challenge any part of the trust, you're going to need to start a lawsuit. This is a point of confusion for many frustrated beneficiaries. But let's pull no punches here. If you don't file suit in court by whatever deadline applies to your claim, in almost all instances, is going to be lost forever. So to pursue your claims, you're going to need to have legal standing to challenge a trust in court, simply meaning that you need to have a financial stake in the outcome of that trust in that dispute. This doesn't necessarily mean that you're going to have to be listed as a beneficiary though. Even if you're an heir, or you can show that you were listed on a previous version of the trust, then most likely the court's going to find that you have standing to file suit. There are various ways to show that you have a financial stake in the trust or its distributions. First, you can be a beneficiary, someone who receives a distribution from the trust. You can be explicitly named or fall into a group of defined beneficiaries, such as all of my kids, all of my grandchildren, etc. But legal standing is a murkier issue if you're not named as a beneficiary. One way to show a financial interest is to prove you would typically inherit some of your loved one's assets, for instance, because you're their child. Another method is to show you were a beneficiary in a prior version of the document, either pre-amendment or new document's creation, and were left out of the current iteration. Finally, you can argue in court that your loved one intended to leave an inheritance, but for some reason their trust simply doesn't list you as a beneficiary. Although these claims really aren't trust contests, as much as they're promissory estoppel claims, which is something that's beyond this discussion today.